In mid-January, quite out of the blue, I received a letter from Officer KT. It was puzzling because it was identical to a letter I'd received and responded to 3 months before. I did as the letter asked and contacted KT. I did so with 3 main objectives. Firstly, to make him aware that a payment plan had already been put in place and that I was honouring it, that I had made payments in advance to cover future weeks, and to seek his assurance that the agency would keep to its promise and obligation not to take further court action. This he gave unreservedly. This is the copy of the original county court application. I was astonished to find that it had been completed by Officer KT on the very day that I'd had the telephone conversation with him in which he confirmed that no further court action would be taken. Look deeper, and this document, obtained under the Data Protection Act, shows the reasoning behind KT's decision. When we look more closely at it, he correctly confirms that I've been making the payments as agreed, but then makes the outrageous claim that I was not making any payments towards arrears. The space in which he was supposed to detail that contained no information whatsoever. This particular document was again completed on the very day that I had the telephone conversation with him. This is a copy of the government's own case file in which details of that telephone conversation are supposed to be recorded. All Officer KT chose to record was that my call was to advise the agency that I'd appointed a firm of legal representatives. None of the other details were included there. Of the 6 crucial facts in the telephone conversation, Officer KT had managed to evidence on the official case file just one, and it was probably the least important. The government-approved procedures which KT should have followed are set out very clearly in these 2 documents. These are the Bibles of enforcement to all intents and purposes, the Debt Enforcement Guide and the Payment Arrangement Guide. It requires that officers act professionally and impartially in discharging their duties, and that they have to correctly apply the agency's enforcement process. The Debt Enforcement Guide clearly stipulates that officers should not take court proceedings when, firstly, the debt is unsafe or under appeal, or there's a payment agreement in place and is being honoured, or 6 weekly payments have been received. Not even government ministers are prepared to explain why I was taken to court by their officers when not one of those 3 requirements applied. The question which perhaps should be raised is whether the officer actually knew what the correct proceedings were. Clearly he should have known and couldn't do his job correctly without knowing. But this document sheds more light on that. It's the annual report of the Child Support Agency Standards Committee, and in it states that the Payment Arrangement Guide had been rewritten, that staff had been issued with advice line bulletins about it, that a training course on compliance with it was available to officers from September, and that they had to attend. He could not possibly have any excuse for not knowing, therefore, what the correct procedures were. The evidence I needed to prove that what I was saying was true, and that the officer had actually gave a commitment not to take court proceedings, and that he accepted that an arrears agreement had been made and was honoured, is contained in a briefing paper produced several months later. Careful examination of that briefing paper reveals some key sentences which perhaps the officer had made unwittingly. She confirms that I had telephoned KT and discussed the agreement which had already been made. It also confirms that KT had advised me that as long as I kept to the agreement, enforcement action would not be taken. Why then, having given that commitment, did KT instigate court proceedings on the very same day? The officer makes 2 particularly interesting comments, claiming that enforcement action was only taken because I did not make any further payments. No further payments were actually due for January, and because of overpayments, that covered the requirements into February, if not longer. She also tries to make out that the court application was issued well after the telephone call. That too is a misleading statement. The forms were completed on the 27th, countersigned on the 28th by a line manager, which was a Friday, and put in the post on the Monday. They could hardly have done it quicker. The agency had tried to make out that no agreement had ever been made with me. When the agency was challenged, the chief executive replied to my MP stating that the agency had never denied making an arrears agreement. The chief executive should know better. This is an extract from his own case files, in which it clearly states on the computer log, no agreement has ever been made with Mr Wood regarding arrears. Yet that is not what he tells Christine Russell MP. The agency, he says, never denied that he made an arrears agreement on the 18th of October. It is interesting that he challenges my accusation that staff have doctored and altered clerical records. There has been no whitewash. If this is not a whitewash, then what is it? The need to follow correct procedure is pretty obvious, particularly where those procedures are absolutely sound. Even when they're not, as in the case of this, arguably, the MP's Green Book on Expenses, a guide for members, at least they could use that as a defence. These two documents from the agency, the Debt Enforcement Guide and the Payment Arrangement Guide, set out the requirements and the procedures that officers have to follow. There's no exception. Why then does it appear that Officer KT didn't follow the procedures stipulated in those books? If I have a suspicion that the answer may lie in the word targets, then it is perhaps no surprise. A report by Bristol University uncovered what it referred to as distorted behaviour and cheating by officers who were driven to meet targets to qualify for pay bonuses. Perhaps that explains why neither the Chief Executive of the agency or the Secretary of State or indeed Lord Mackenzie appear particularly willing to answer the questions which I ask. What are those questions? I'd like to know why Officer KT broke his promise, why he told me one day that he wasn't going to take me to court and filled in the forms the very same day to do exactly the opposite. Why are the details of that telephone conversation not to be found on the government's case file? Did KT put them there for somebody later to remove them? Or did he decide he wasn't going to put them there in the first place? Why, if these were genuine mistakes, did Officer KT not contact me? Why did anyone not contact me to put matters right? The public have to rely on organisations like the Independent Case Examiner to put matters right. Why could the experts there not find the evidence that I found? Why, even when I disclosed the evidence which showed that the judgments in the report were unsound, has the Independent Case Examiner not withdrawn his report or taken steps to actually put it right as I've requested? As for what should happen next, let's listen again to what the Prime Minister said the solution was.
Must show that where mistakes have been made and errors have been discovered, where wrongs have to be righted, that is done so immediately. And we have also to try hard to show people and think hard about how a profession that, like yours, depends on trust. The most precious asset it has in trust is trust. How that profession too can show that it is genuinely there to serve the public in all its future needs.